After representing himself at trial for a misdemeanor, the defendant received a suspended sentence. The United States Supreme Court agreed to hear the case of Alabama v. Shelton to settle the Sixth Amendment issue of whether the right to court-appointed counsel applies if the defendant isn't actually incarcerated. LeReed Shelton had been charged with third-degree assault, a misdemeanor carrying a maximum punishment of 1 year in prison and a $2,000 fine. He represented himself at a bench trial and was convicted. He invoked his right to a trial by jury and represented himself again. The court warned Shelton of the dangers of self-representation, but never offered to provide him a lawyer. The jury convicted him. The court sentenced him to 30 days in a county jail, but immediately suspended the sentence and placed him on 2 years probation. Shelton appealed his sentence on Sixth Amendment grounds. He argued that because there was a chance that he'd have to serve jail time, he was entitled to court-appointed counsel. The Alabama Court of Criminal Appeals affirmed the conviction, holding that a suspended sentence doesn't trigger the Sixth Amendment's right to appointed counsel unless there's evidence that the defendant has actually been deprived of liberty. Because he was never imprisoned, Shelton hadn't been denied any Sixth Amendment rights. The Alabama Supreme Court reversed, holding that a suspended sentence constituted a term of imprisonment even if incarceration wasn't immediate or inevitable. It affirmed Shelton's conviction, but invalidated the sentence of suspended jail time, which also invalidated the probation. The United States Supreme Court granted certiorari.